Hi, I'm Richard Murray, CEO of Eurolink.
I'm Dan Anslow, Head of Product at Eurolink.
And I'm Carly, Director at Woodstock Legal Services. And we are specialists in property litigation, but more specifically residential landlord and tenant. And we do evictions and rent arrears recovery, work for landlords all across England and Wales, which gives us a real insight to the challenges that they face and their agents.
Great. Okay. Carly, let's just dive straight into this. So post-pandemic world, how does a landlord repossess? How do they get their properties back?
So the good news is that we are back to, essentially where we were pre-pandemic. So you're back to just your standard 2 weeks notice for your rent arrears recovery and possession on those grounds, and then 2 months for your Section 21. I guess the bad news is that the courts were already quite slow. The system's fairly archaic, and it's going to be a bit slower. It's not as bad as I think we were fearing, but it is slower, and that's why it's just so incredibly important that your paperwork is spot on.
Yeah, and I guess everyone's finding that, but very much in the legal system. Yeah. So I guess if we go back to the sort of start of the process, if you like, I guess we'd be talking about tenancy management, arrears. What would you recommend in terms of how an agent can use best practice to manage it from a legal perspective, and then we'll talk about it from a product perspective, maybe.
Yeah, so tenancy compliance is just incredibly important. What we're seeing, and we'll see even more when we talk about reforms, but there's a real professionalism of the industry, and where if you go back to the intention of the legislation, it was never to have a 6-month tenancy. So landlords, and that's how most people operate. But landlords are on the back foot. We've got a problem with housing in this country. It's really difficult to find a rental property. Homelessness is a real problem. So, judges aren't inclined to make a possession order unless everything is perfect. So for agents and for landlords, it's so incredibly important that the paperwork is perfect, so that when it comes to legal proceedings, there are no bumps in the roads. There's nothing that might cause us a delay or, give a judge, opportunity to question whether a possession order should be made or delay it at all.
And how minor could that be? How minor?
Really minor. Yeah, and I think you've got to remember, a lot of the judges that are sitting there in front of you, some of them are incredible, but you've got to remember sometimes with the court system we've got now, a lot of them are family judges. They're not housing specialists. Okay. So you don't want to give anything that they might, just question and not be sure of. We've got to be, a step ahead of them. Everything's got to be perfect. So, there's some really minor things that they might not be quite up to speed with the legislation. So if there's a minor challenge by a tenant, anything that they think in this 10-minute hearing, which is really quite short, or in a stack of paperwork, if you're talking about accelerated possession procedure that they're not sure about, or they think needs a bit more investigation, or they want to hear from the tenant, that can cause a delay.
So what happens? Is it not back to square one, or is it you're back into that backlog scenario that you're talking about?
You are. And if I take as an example a Section 8 procedure, so we've issued proceedings on a Section 8 because rent arrears have accrued. We go to a hearing, and for example, there's a counterclaim that's issued on the day, which they can do. They've got a deadline where they're supposed to file a defence and a counterclaim, but they're really lenient for tenants. They could turn up and file that on the day. Or they could turn up and say, I haven't received the notice. And if you haven't got really concrete evidence that notice has been served, and that the rent arrears are correct, for example, if they turn up and challenge them on the day, in 10 minutes, if a judge thinks they can't deal with it in that time, they all adjourn. And you'll be back waiting for your next hearing, which, can take months in some courts, unfortunately.
Yeah, that makes sense. So essentially, don't give the judge or any party any excuse. Don't trip yourself up, I think is so really this is all in the agent's hands.
Yeah, and it's about compliance, managing risk, and ensuring that everything is, they really understand the portfolio, they really understand every single tenancy, what's going on, everything's recorded, the evidence is there, you've got solid paper trails, audits,
Yeah. And a lot of the time you're relying on obviously systems.
Yes.
I mean, we would always say use a system like Veco. Use a good system to record all this information. You're still reliant on users to a degree. I'm sure there's things that Dan will want to talk about in a minute that can help with that process. But you've still got an element of obviously reliance on that those individual users. So from a product point of view, Dan, what what's our approach? What can we do to help agents keep that compliance absolutely spot on?
Well, I think ultimately from a CRM such as ours, we're actually a facilitator to allow our agent or our clients to be compliant and ultimately protecting their landlords when they're looking to go through something like possession. So I think it's just key, sometimes being the basics of recording every communication that goes out, make sure everything's time and date stamped, making sure that you've got the ability to report on it, because as much as we want to make it easy, we're taking the administrative overhead out of doing that reporting to allow it to go back to the agent and through to possession. So it's all about getting the key points right and making sure that we've got the key compliant elements recorded in the system so that they can be pulled out and ultimately aid the case going forward.
And this could be anything. It's not just talking about arrears here. It could be any part of the compliance process, I guess.
Yeah. So, you talked about time and date stamps. They're almost like a lawyer's dream. We're talking about sort of pre-tenancy documents. That's been a massive challenge for landlords and agents to ensure that they can gain possession on a Section 21 no-fault possession proceedings. And we've seen so many challenges where agents, and most of the time they've complied, but they're not able to evidence that they've complied when serving the pre-tenancy documents. So your gas safety, your energy performance certificate, the right how to rent guide, all of the right one that's the current version that they're updated fairly regularly and they get slipped in without much notice. So like I say, time and date stamps, audit, a trail of evidence is really, really good for us.
So taking advice from companies like yours, allowing them to make sure that we could get everything right. We could help the agent get everything right, but one mistake like being behind on a version, even just version control of documentation
really
is crucial.
Yeah, so it's little things like we recommend our agents always go direct to the website because they're very often they're not very publicly announced that it's been changed. So it's really important that they go direct to that. I've seen really, really good agents that on the face of it have got a great system, but it's not centralised enough and there's too much room for human error. So I've had a case, for example, where I've got evidence of an email with the energy performance certificate attached. So I've got evidence, it's named, attachment, energy performance certificate related to the property. And further investigation at the hearing showed that actually the energy performance certificate that was attached actually related to a completely different property.
Oh, no.
So you can see how systems, if they're not sophisticated enough, when you're dealing in these volumes and people are busy, how they can easily make a really minor mistake.
Because that's best intention.
Yeah, it is.
That is absolute best intention.
Yeah, they're generally trying to do a good job, and this is a good agent. But it's I've seen agents are using systems where they get tenants to sign to say they've had all of those documents, but unless you can show that it's that particular document, and then you're sat before a judge and a tenant says, I didn't get that, and how do you can't prove it. So on the balance of probabilities, judge is likely to favour a tenant instead of making them, effectively homeless. The outcome of the hearing is serious. It's somebody's home that you're talking about. So you can't give them anything you've got to make sure that, the I's are dotted, the T's are crossed.
Absolutely. So if time and date stamps are important, that's an interesting point because forever we've had a notes system within our software, and literally when you do something as a user or it's automated, because we should talk about, automating the sending of that EPC that you just talked about. It can't go wrong.
No,
you can't attach the wrong EPC because it's the EPC that's attached to the property. Unless that was wrong, of course. There's always maybe an edge case to something going wrong. But what the approach we try to take is if everything's in a note, it's time and date stamped, and our users, our clients, we cannot change that. You can't overrule it. You can't delete it. You can't edit it. You can't, for want of a better phrase, fudge it. Yeah,
absolutely.
It's there, and we've found that when our clients have been to court, if you like, then they've been able to present that as a feature in their software.
Yeah, very much so. Yeah,
and I'm guessing that would help, or it seems to help our
definitely.
clients.
And I think as well that you can demonstrate to the court that you know what you should be doing and you've got really strong processes. And even if there is a mild accusation that something could have gone wrong, if you can demonstrate that 99% of the time you're getting it right, and we really don't think we got it wrong on this occasion, I think you're more likely for them to find in your favour.
Okay, makes sense. Yeah. So from an automation point of view, from a systems point of view, and as a product man, how can we help, or how can automated systems help? Let's say.
Well, ultimately, you're leveraging the data in your database to be able to provide an end result. So we take something like an arrears chasing element. We know the number of days a client is in arrears, and we know the value they're in arrears at that point in time. Using the automation part of the application just means that we can send that out in a timely manner. We can have it, what was sent out, attached to the record, a time and date stamp when that was sent out, and therefore you can see exactly what happened without having to go through someone's inbox or outbox, sent items, without having to go through another third-party system. We're centralizing the output of the system, which has been leveraged by the data, to make sure that we've done what we should, or we've said we've done at the right point in time.
So if we would recommend automating as much of the process side of it as possible, and then we're able to, or our clients more importantly, are able then to show a full audit trail of everything, that's got to help that 10-minute hearing process.
It makes it really easy for them to instruct us in the first place, which means we can react a lot quicker. And when you're talking about rent arrears, time is of the essence. It's really important that you act quickly, particularly where we're saying that the court systems, unfortunately, in their current state, are very slow. So the quicker we can be instructed, and then the quicker we can review and say, these guys have got everything in line, we present that to the court. It's very difficult for the judge to pick holes in it, and it's very difficult for somebody else to challenge on the day.
So that's far more efficient generally, but also I guess it's far more economical if you're not having to do a lot of the work, a lot of the chasing. So our client, if you like, the agent, can then come to you with an efficient file, efficient pack. That will then ultimately cost them less money.
And we operate on fixed fees, and a lot of people that work in the same specialism do operate on fixed fees, and it's how the market is structured with pricing. So for us to be competitive on fixed fees, there's lots of agents that we work with, and we do a more competitive fixed fee with them because we know they know their stuff, we know their processes are good, and we know that they can quickly instruct us. We can check through the paperwork efficiently, know that everything's satisfied, and we can present the paperwork to the court knowing that everything's been done as it should be.
Sounds good. Makes sense. So that's where we are now. So you're advocating professionalism, making sure that agents are really on top of the compliance. We're saying use a good system, automate as many of the repetitive business processes as you can. Time and date stamping clearly is a big part of it, being able to categorically prove that a certain communication happened on a certain day at a certain time. So that's all great advice to the agent, and good to know, for all the right reasons, that we're back to where we were, albeit with a bit of a backlog. Obviously, lots of changes are afoot now. So, would you mind sort of talking everyone through the what is happening, or what you think might happen as well?
Okay. What I definitely know is happening is there is a huge amount more of disrepair claims. So before we talk about the big reforms that are coming, that's a really key thing for people to take away, is that we are seeing so many more disrepair claims. And it's so important that agents and landlords are on top of the management of complaints about disrepair, so that we can quickly demonstrate to a court that they have complied with their obligations. It's really difficult to get trades in. We know that there's a shortage. So you've got to be able to clearly demonstrate that you have done everything within your capacity to get a tradesperson in that property to do the work that the tenant's complained of, and that you've rectified the situation. So that's one thing we're seeing. And we see those as counterclaims to possession proceedings, and I think we'll see more. We saw lots from the pandemic, I think, where you had a period of people choosing or being unable to pay their rent, and then thinking, I need a reason why I didn't pay my rent, or I can't find that money, I need to try and offset it. So we saw lots of those, and we will see lots of standalone claims as well, no win, no fee organisations set up to pursue those claims. And then the big thing we've got coming is reforms. There's been talk for a long time about Section 21s going. I have no doubt they will be abolished. It is coming, and they're talking about spring. I think we're in spring. So there's obviously a lot going on in the world. When will it happen? I don't know. It's still fairly vague as to exactly when it will happen and what changes they will make. But essentially what they will do is redraft the grounds for the fault grounds. So previously, most people were relying on antisocial behaviour, fairly rarely actually, but and rent arrears recovery for grounds for possession. And what they will do is reconsider those grounds and redraft them to accommodate the reasons that people were previously serving a Section 21. And it's and whilst it's a no fault ground, it's not a no reason ground. Most landlords that are, serving a Section 21, they're doing so for a valid reason, moving back into the property, having to sell, it's becoming increasingly tough for landlords to navigate, this is a business. And, there are quite a few that are opting out, and we're seeing perhaps more portfolio landlords that are running it as a, professional setup as a business rather than less sort of one-off accidental landlords. So, that's, one of the reasons we saw quite commonly is, landlords moving back into the property, landlords selling. So they'll redraft the grounds to accommodate for those reasons. So in theory, every landlord that ever wanted to evict for a valid reason will still have the ability to do so.
Yeah.
They will have to evidence it. And that's the big change.
As we've been talking about.
Yeah, exactly. So that becomes
that,
increasingly important. And, we just had the Levelling Up white paper. It's quite clear what we're moving towards is really trying to drive up standards of housing in this country and rental accommodation. And really driving up the professionalism of the industry. And we've been going that way a long time, and this would be a further push towards it. And they've talked about landlord registers and also increasing security of tenure. I talked earlier on about how it was never the intention to have 6-month tenancies. The intention was always to give tenants security of tenure. This is their home, and that's what we're essentially talking about. It's somebody else's investment, it's somebody else's property, but this is a tenant's home. And what we're pushing towards is that those homes are of good standard. And that they've got security of tenure. So they won't be evicted, for no apparent reason. Unnecessarily so, with little to no notice. But the reality is, people have been using Section 21s for other reasons because they thought it was the quickest and most efficient route. It actually hasn't been for a long time. But so that's what we're moving towards. And that's why tenancy compliance, records, evidence, and, really good property management will be key.
And this disrepair point that you're making, I know you believe could be the next, next big sort of.
Yeah, I do, and they're pushing up, standards of housing, so landlords will have to be on top of it, and quite rightly so.
Yeah, absolutely. Yeah. And again, a good product will assist with all of that. But even if it's ad hoc repairs, again, the audit trail of a works order, of an instruction that we can again time and date stamp and hold notes against. Our integration with Fixflow will add to that that compliance and being able to evidence who's been involved, when, where, how. So we're okay.
Yeah, all things a lawyer loves to see. If I'm doing a witness statement or I'm drafting pleadings on, in response to a claim for disrepair, if someone presents me with all of that, it's really great evidence that I can, try and get rid of that claim before it even needs to go to court. So I can say to the tenant, look, it's not the case. They've clearly complied with their obligations. It's one thing there being a problem with the property. These things happen. We know, properties, boilers stop working, but it's how you react and how quickly you deal with it. And if we can evidence that they've complied with their obligations, then we can get rid of those claims and we can deal with, gaining possession or the rent arrears amicably, and quickly and efficiently.
Sounds good. Look, it's really good advice from both of you. So if anyone wanted to know more about Woodstock Legal Services, where should they go? What should they do?
Go onto our website or, contact me, call us. We've got a very friendly team. Our aim is always to give very practical legal advice. We're niche specialists. So these guys, my team do these claims day in, day out. And they work with an array of agents, landlords, big, small. They're a nice bunch and they know their stuff. So pick up the phone and give them a call.
It's good. We would highly recommend you. We've met you through ALA conferences and your knowledge and commitment to the industry is apparent. From a Veco perspective, of course, contact your Veco CRM if you'd like to discuss software.